So what would have been the effect if you get a subpoena and an order saying don't destroy any of these documents? What would you have done?
Congressman, we don't destroy anything, but it kind of creates a constitutional crisis when they come into your apartment and take your things in order, and then they ask you to divulge source information in order to prove that you're innocent. That it's kind of a tautology. That's what we're facing, and there are all pre-existing rules that the Department of Justice is not following. That's why I'm calling on the legislative branch to do something about it, and they have to unseal the affidavit that contains whatever probable cause was in this case, and they have failed to do that. They have not yet done that.
I'm wondering if maybe it's time to go back to pre-78 and not have FISA courts anymore. Just your quick reaction, both of you, if you would.
There's clearly a disparate treatment at the Department of Justice, including how they define journalist. In the amendment here, I have the quote, covered journalist. Term covered journalist means a person who regularly gathers, prepares, collects photographs, records, writes, edits information that concerns national stories. The Southern District of New York wrote in pleadings that I'm not a journalist because I don't get permission from the subjects I investigate. So that directly contradicts common sense as well as the law. So obviously we can't trust the Department of Justice with the power to define who is and who is not a journalist, just depending upon who's in charge. That's against everything the First Amendment stands for, sir.
Mr. O'Keefe, has any court found that Project Veritas is a journalistic organization protected by the First Amendment?
Congressman, yes. We've been in litigation in a number of cases, defamation cases that we've won on summary judgment, directed verdict. In fact, Project Veritas is proud of our legal record. We've really never lost a lawsuit. We've overturned the law in federal court in Massachusetts to prevent two-party consent. Numerous Article III judges have referred to us as journalists. So again,
within the judicial process, you're deemed journalists, and now there is this extrajudicial process, whether it's going behind special masters, whether it's getting third-party secret orders to turn over records related to you that seem to violate what would be a straight-up presentation of facts and review. I learn something more every time I hear you speak about this. I had no idea that the department had tried to do an end run around a special master process. Would you mind taking a few moments to explain how you did that?
Yes, Congressman. The Article III judge in New York, Southern District, Judge Torres, ordered a special master be ordered in my case in a two-page directive citing, and I quote, First Amendment journalistic privilege. After that, they went around the judge to various magistrate judges in the Southern District to obtain a secret warrant against Microsoft to continue to gag Microsoft Corporation, which houses our emails. They tried to gag Microsoft after the federal judge, the judiciary appointed a special master, citing the First Amendment. So why would we trust the FBI and the Department of Justice to define who is and who is not a journalist? And credit to Microsoft, because Microsoft opposed the gag, and when they drafted that opposition, the Department of Justice backed down. And we went public with that in March.
Was there any reaction by the court, any discipline imposed on the Department of Justice for seeking to go and run a judicial order?
Not to my knowledge. We have filed what's called a 41G motion to get our journalistic equipment back, and the judge ordered the Department of Justice respond to that motion. They responded on Friday to our arguments, and that's where this Privacy Protection Act, they say it does not apply, and they made a number of arguments saying, and this is quite absurd, the government called our First Amendment arguments a newly invented privilege and novel theory.
There were physical copies of legal memos prepared by one of your lawyers, and that they had been put into the possession of the New York Times, presumably through, I mean, your conjecture was through the FBI, I guess. Do you have any further insight, or can you relate anything about that to this gathering?
Well, when the agents came to our journalists' homes with the battering ram, they, within minutes, a very short period of time after the raid occurred, we received text messages from national security reporters at the New York Times, including a man named Mike Schmidt, who somehow knew the circumstances and specific situation, and then some few days later, the New York Times published our attorney-client privileged documents, and a judge in the Supreme Court of New York ruled against the New York Times doing that. That's involving a defamation case against the New York Times.
Any further developments on that point? I know the New York Times thought it was outrageous that they'd be dispossessed of your privileged legal documents, but I think people are probably rooting for you.
Well, there's clearly a distinction, and it's sanctionable conduct in New York State because we're in litigation against the New York Times for defamation, and they're publishing my attorneys in that litigation's private privileged communications, and they appealed that, and it's currently in the appellate division in New York State.
You raised a lot of eyebrows from most people who just didn't know that was going on. Were they involved? Is a collusion, in your opinion, with what's happening really to both of y'all, in your opinion?
I don't want to opine on who or what forces are behind this, or I think Ashley Biden's attorney's statement about sending it to the SDN, we should send to the SDNY, is self-evident. There's also a poster in the room. You can see the 4 photos there. We find this extraordinary, that Roberta Kaplan is the same attorney for Ashley Biden. She's also the same attorney for former Governor Andrew Cuomo, and she represents the woman married to the son of the U.S. attorney who signed all the secret warrants against me. So those are the facts. Those are pretty self-evident facts, and I don't wish to opine beyond the facts.
I assume you've been banned like Babylon Bee and God knows who else.
We are banned on Twitter. Project Veritas is banned on Twitter. I'm banned on Twitter, and Instagram does not allow the user to tag us. We are currently in litigation against the New York Times for defamation for calling us disinformation pertaining to a report we did on ballot harvesting, which the judge in New York ruled against the New York Times on motion to dismiss and called in deception, and ruled the case go to discovery in New York State.
There's a phrase that's been coined that I'd like you to speak to if you can, and both of you can jump in. I first heard it from Matt Gates over here, but it says the process is the punishment, in the sense of you could end up going through this whole process and proving your innocence, but the process ends up being the punishment. Could you speak to that? What you're having to do to defend yourself?
Well, the whole idea of journalism is to get sources to trust you. And what do you think sources think when they put this journalist in handcuffs and take all their reporter notebooks? The chilling effect is self-evident. Maybe that's what they're trying to do. Either way, the legislative branch has to make sure that doesn't happen. And the problem with probable execution of a search warrant, the ACLU lawyers were in my office, which was itself an extraordinary fact to the principles involved here. And what they informed me, this has never happened before in American history. And I want to make sure that it never happens again to anybody. You don't show up to a journalist's home with a battering ram. Probable cause against a journalist, as soon as they walk into your apartment with the battering ram and guns pointed at you, there's no remedy. The constitutional violation is already too great. You've already passed the Rubicon. So this can't ever happen again, until which time there's what I call a Bartnicki hearing, with the burden of proof has to be on the government. The federal rules of criminal procedure make this clear. The Privacy Protection Act makes this clear. Attorney General Merrick Garland made it clear in July. They just broke their own rules. They broke their own rules. So now it's upon you, with your enumerated powers, to do something about it. so that they don't do this to Josh Gerstein at Politico or NBC News or CBS News. They did it to me. I hope they never do it to anybody ever again.
Given what we've seen through the last year, this question is for both of you. Do you believe that the attack on journalists is an isolated incident or another arm of Biden's war on conservative speech?
Thank you, Congresswoman. For me, it's the disparate treatment, the unequal application of the law. You pointed out Madison, the founding fathers, the First Amendment specifically says press. It's a special activity that's specifically mentioned in the First Amendment, and therefore that's why this is so important. Under the Trump administration, the Department of Justice did attempt to do warrants against Google for New York Times information, but allowed Google to disclose the presence of those warrants. It got to New York Times lawyers. They were able to fight them, and it went away. In our case, that did not happen. The Department of Justice did not allow us to know the existence of the warrants. In fact, they gagged using magistrate judges Microsoft from telling anybody about that. That's should not happen on American soil. And it's the disparate treatment under the law that we have to get redress for.
Perhaps we need a completely different org chart, a whole different structure for this. And I wonder if we were to look at this in a blank slate, if either of you have given thought to how might we ought to be organized.
I think that accountability really, from our perspective as news people, is sunlight. That's the accountability. You all derive your power from the consent of the governed. So that consent can't be manufactured. And what has happened here, and what I've testified about, the battering rams, the handcuffs, rifling through notebooks to identify sources, we have sources in the government who have been chilled out from coming forward to educate people and outrage them about what's happening in the intelligence agencies. And they can't do that. So for me, it's circular. And that's why there has to be this reform. There are rules. There are criminal rules of federal procedure and Privacy Protection Act and Attorney General's own memos. They just violated it. So that freedom to bring the information forward, and there needs to be some standard. It's on the government. If they're going to raid a journalist's home, again, I go back to this concept that there has to be a clear and convincing standard. It can't just be, we need to look through your anonymous sources so that you can prove that you're innocent to us. That has to be changed.
Yeah, you've highlighted some really important laws that do need to be changed.
I am curious to know how they have proceeded, and from an ethics point of view, as they've been involved in this with regard to Roberta Kaplan.
Well, the graphic there speaks to the relationships. Again, she's the lawyer for the daughter-in-law of the U.S. attorney who signed the secret warrants. We understand the law of the land is that you need permission from the Attorney General of the United States to execute a search warrant, for the FBI to execute a search warrant against a press media company. I'm not aware of that ever happening before in American history. That's what the ACLU told me. They're defending Julian Assange in his case. But we have no reason to believe they went to Maine Justice to get that approved. Either way, their attempts to say that I'm not a journalist in opposition to the special master is absurd, and their recent, last week, response to our return of property motion, completely ignoring any First Amendment argument that we made, shows bad faith.
How did you find out about the second route that the FBI was using?
Second route.
Yeah, I mean, as far as they were going around the special master.
We found out because after the federal judge appointed the special master in, I believe it was December 8th or thereabouts, there was warrants that were unsealed later showing they went to try to gag Microsoft Corporation with these 2703D gag orders to try to prevent Microsoft from telling anybody about what happened after the case was public and the federal judge cited First Amendment privileges. So for the Southern District to continue to shop around the magistrate bench of New York to try to continue to silence Microsoft, that behavior is beyond unethical. And Microsoft, credit to them, fought back, and that's when all these warrants became unsealed and we found out about it.